In the wake of the Alberta government passing Bill 2 and invoking the notwithstanding clause, the leadership of the Alberta Teachers Association is recommending to challenge it in court. So what options do they have, and how effective might they be?
We'll be back in the classroom.
The point of the Alberta government using the notwithstanding clause is that it prevents the ATA from challenging the legislation by overriding the Charter of Human Rights. But the ATA could challenge it in court anyway.
The court can make a finding as to whether the law infringes a charter right. So in this instance, they might ask a court in Alberta, notwithstanding the notwithstanding clause, does this law violate the right to freedom of association?
It likely wouldn't equate to a reversal of the legislation, but if it's deemed to infringe on a charter right, it could be considered a moral victory.
It's helpful for the public to know, did the use of the notwithstanding clause here actually violate people's charter rights? And that's something that a court can tell them.
And the Canadian Civil Liberties Association is watching.
Our interest is not the strike per se. It's the way the government has responded to the strike by using the notwithstanding clause.
Howard Sapers is a former Alberta Liberal MLA. He says the notwithstanding clause wasn't supposed to be a shield for government, but one to protect vulnerable groups. The CCLA says it will be watching the ATA's next steps closely.
Certainly, we would look with keen interest if there was litigation launched to see whether or not there's a reason to intervene in that.
So Alberta did use it.
Christopher Samuel says the clause is intended to be used after the courts have examined legislation and not as a preemptive move. He says if not challenged, it could become a government shortcut.
It becomes easier over time for governments to reach for that shortcut if it becomes normalized. And so that's the concern that I think Albertans should have, is the normalization of this type of legislation.
Saskatchewan used the clause to back a pronoun law in 2023, and Quebec invoked it in 2019 for a law on secularism. Both cases are being appealed at the Supreme Court, with Alberta likely watching the outcome. Travis McEwan, CBC News, Edmonton.